My name is Mesia Martinez. I'm a criminal lawyer in Spain since 1994, and I would like to thank the European Criminal Justice Observatory to let me know to explain the new circumstances and the new changes of the law, especially the criminal law in Spain. First of all, what I'm going to do is I'm going to explain what I'm going to talk about. The first point, according to the changes of the law, it will be, we're going to talk about the pre-trial detention in Spain in relation with Europe, the other countries in Europe. The second point, it will be the right of defense. The third point will be the instruction and investigation of the case by the prosecutor office instead of the judge. The fourth point will be the right of defense. The fifth point will be the right for the accused in prison and the lawyers to do not intercept the conversations and communications between both of them. The next point will be the whistleblower proceeding in Spain in relation with the rest of the countries in Europe. And the last point will be the agreements between the court and the defense lawyers. First of all, I would like to explain regarding the pre-trial detention that the new government directed by the Ministry of Justice in Spain, Mr. Alberto Ruiz Gallardón, they decided a few months ago to continue with the job that they done the ex-Minister of Justice, Mr. Camaño, in terms of change the old law that we call Ley de Enjuiciamiento Criminal, criminal proceedings. That date is very old, it's been used in 1882, more than one century ago, in terms of their pre-trial detations. The new expert commissions, they said that we have to change this law, especially this article, when they said, the law said that the length time is 4 years in prison, pre-trial detentions before the hearing. The experts, they said that we have, and the law has to be changed and reduce this time period in pre-trial detentions, because it's an abuse, for not just for the accused and the person that is held in prison, but also for the system, the judicial system, and also for the families, that they also have their rights. So, what did they say that the experts, they said, criminal experts, designed by the Ministry of Justice, they said that it has to be changed. It will be changed for 3 years maximum time. Also, they said, this is what I think is logical, they said that for organized crime, and it depends on the case, it will be the period of time 4 years as well. An organized crime is when more than 2 persons organize to commit a crime. That means if 3 persons organize together to commit a crime, that will be an organization. And the time limit, the length of time for pre-trial detention, it will be 4 years as well. So it's illogical what the law says right now. It says for 4 years time maximum. And the experts have said it will be 3 years, but if there is an organized crime, 3 persons that organize to commit a crime, it will be 4 years. Most of the trials and the proceedings that they are instructed and they are resolved by the national court, where the organized crimes are decided by the judges at the national court, are organized crime. So at the end it's the same. I mean, they try to say for the public, for the European Commission, that look, we're going to reduce the length, pretrial detention length time, but at the end it's 4 years as well. So they didn't do anything at all. The European Commission worked very hard with organizations like Federation International and others to try to explain to the European Commission, especially the Commissioner, Mrs. Viviane Reding, to reduce the time, because it's an abuse, it's illogical, is a person who is held for 4 years in prison is a person who is innocent, and because the prosecutor thinks that he must stay there for I don't know what reason for 4 years, that's an abuse, and it goes against the European Court of Human Rights law. So the European Commission, they think very hard in the last 2 years, and they said that, okay, we're going to apply the European Supervision Order. That means that the pretrial detention in Europe has to be the minimum length time, like, for example, in England, that is a country where there is more persons in the population in prison is the biggest one in Europe, and the length time for the pretrial detention is less than 190 days. So it's less than 1 year, a little bit more than half a year. In Spain it's 4 years. In other countries, like in Spain, it's 4 years as well, but most of them are around 6 months period of time. And others, they said that it depends on the crime, but not most of them, they keep a person in prison in pretrial detention for more than 4 years. So in Spain, they say that the European Supervision Order, instructed by the European Commission, they said that we'll see if they apply or not, because they don't have the obligation, they're not obligated to apply it. And we'll see what is going to be the result. But at the end, because of the money that the government spends in pretrial detentions, the vulnerability of the law and other circumstances, it has to be reduced at the end. The second point I would like to explain in this video is the right of defense. The new law that is going to be changed in a few months in Spain for the right of defense, it says that the person who is accused in a criminal proceeding, this person will not allow to interview with their lawyers in front of the police or before they make a statement at the police. This is going to be changed. The law says, the experts say that the person who is arrested has the right to interview with his or her lawyer before they present or they make a statement in front of the police. I think it's logical, because they will solve a lot of things, a lot of problems right now, because most of the people say they don't want to make statements until they make an interview with the lawyers. And of course it's going to be better for the defense, and it's going to be better for the system. The other point is that the person who is going to have a trial has to be in front of the judge for a criminal proceeding, criminal trial. The person will sit behind his or her lawyer, and this person, the accused or co-accused, will present statements at the end of the proceeding, after the witnesses and the expert witnesses make allegations in front of the judge. Right now, the system says that the first person who has to make statements is the accused or accused persons. This is going to be changed, and I think it's a good point. What I don't like is that we follow the proceedings, or the criminal proceeding from the United States, as always. And we have a judicial, especially criminal system, very, very different than the United States of America. The other point is the right for the accused persons to do not have intercepted their communication with their lawyers, unless we're talking about a terrorist proceeding and the judge has enough evidence to prosecute the lawyer because they think the investigations prove that they have connections with terrorists. Okay, right now the systems, after all what happened in Spain regarding the telephone intercept with lawyers and accused persons in economic crimes, this is going to be changed as well in the new law called Código Procesal Penal, Proceeding Penal Code. The next point is the investigation from the prosecutor. Right now, the judge has the power to investigate every crime. Every single crime has to be investigated by a judge, right? This is going to be changed. The person who's going to investigate the cases, criminal cases, is going to be the prosecutor. It's good or bad? Well, there's a lot of people who's talking about this in Spain. Some of them said if it's good, if they really have independence, and the others say that's bad. Of course, it's going to be a guaranteed judge who's going to control the investigations, criminal investigations done by the prosecutor office. And the good thing is that the prosecuting office is going to be a length of time to investigate the crime, and it won't be more than 16 months, 18 months. The minimum will be 6 months, and the maximum will be 18 months. Right now, in our office, we have cases that they start in 2005, another one that started in 1997, that they start in 2001, 2002, and at the moment it didn't finish. Why? Because the justice system in Spain is collapsed. And why? Because, for example, in Madrid we have 50 investigation courts. Each one of them, they have more than 5,000 cases, criminal cases, per year. And they work between 9:30 and 2 o'clock. So, we don't have money to get to extend the time work for the judges. Well, we don't have money, and the government, what they're doing right now is they are reducing the salary of the judges, prosecutors, lawyers, state lawyers, tax lawyers. So it's not that they cannot extend the time and the salary, is that they're reducing the salary of the judges. So this is getting, in my opinion, worse. Because the judges, they said, if they cut my salary, I don't have, they cut, for example, around 50% my salary, why am I going to work 4 hours? So I think this is logical. Well, I think the investigation of the prosecutor, I don't think it's going to be good in Spain. Why? Because for centuries the investigation has been done by the judge. And in conscience, the prosecutor has the right, and their job is accuse, and more accuse. Keep the person in prison until the trial, and accuse, until the conscience of the prosecutor office in all the cities in Spain, all the towns in Spain change. This, in my opinion, is going to be a big mistake. And I don't think the prosecutor office has the persons in their offices to make a good job at this moment. Why? Because there's no money. And until the government put more money in justice and less taxes in justice, this is going to be a big mistake and a big mess. So, what I can, and I would like to continue, is the secreto sumario, summary secret. They said, the experts said that the new law has to contain reduced length of secret of the cases. It's going to be a good thing because a person who has their cases or their proceedings in secret, they cannot defend. and nobody will be, and no judges will take a decision to release a person until the case is open for everybody, prosecutor office and the defense. So if this period of the secreto sumario summary secret is reduced, the length of time, it will be better for the defense right. The next point is the whistleblower proceedings. The exodus of the new laws, they said that every person who collaborate and help the prosecutor office, the police, to resolve a criminal proceeding, it will be not acquitted and the proceeding will be finished for this person, this accused person. Well, this is very, we didn't see the law and we didn't see the expert's document, but I mean it's very dangerous because every person will say, you did it, this person did it, I didn't do anything, or I do this, but this person do that. The other person will say this, or what another person did it, and at the end, who's going to be sentenced? If all the persons who accuse another person or who blow the whistle regarding a situation or a person, it's very difficult. What I mean, we see what the text and the law says, but it's very, very difficult. They didn't do in Spain. What I will suggest the government is we have to protect the whistleblowers, and we have to protect and give them something else than protection. In the United States and in England, they give money. If a person denunciates or sue a person because they he see or her see that it's committed a crime, if the government takes or receives money, amount of money more than $1 million, the whistleblower will receive between 10 and 30% of this money. And this is a good thing, because they present and then they make laws to protect whistleblowers. In Spain, the whistleblowers are not protected at all. So I think Spain and the rest of the countries in Europe, they should do something what the United States did in the Dodd-Frank law and the Sarbanes-Oxley law, is try to get information from other people, whistleblowers, that they decide to whistle the blower because they really think that they're doing a good thing for the community. And these whistleblower proceedings and laws started in the United States in 1777 with the President of the United States of America, Abraham Lincoln. So this is changing around Europe, and we'll see what happens at the end. Another thing is good. I think is a very good point regarding the change in the law regarding the experts document. It's the agreements and settlements between the prosecutor office and the accused and their lawyers. Right now, if you are in a criminal proceeding that the prosecutor will ask or is asking a penalty higher than 6 years, you cannot make an agreement, and the trial is going to be celebrated. Then at the end, the judges, especially the prosecutors and the things, they really are applying agreements. But according to the law, it can't be done. Proceeding between months in prison and 6 years, you can deal with the prosecutor and try and make an agreement for the accused person for 1, 2, 3, 4, 5 or 6 years. But what I said, if the penalty is high, you can make an agreement with the prosecutor. With the new law, this agreement can be done any moment of the proceeding, and the accused won't celebrate the trial. Just it will be an agreement with the prosecutor and with a penalty of a prison sentence and with a civil proceeding and money. At the end, it's money. Regarding the jury, the law is going to be changed. Yes, and the jury proceeding will apply only for criminal cases regarding the life murder, heinous murders. Right now, you can have different possibilities to celebrate a hearing with the jury proceeding. This is going to be this proceeding is going to be taken only for murder proceedings and homicide. Regarding the right to lie, we do have the right to lie. This is what the Constitutional Court says. The person who is accused has a right to not give evidence to the police, to the judge, and to lie. This is something that the constitutional law doesn't say nothing about that. The constitutional law in Spain says, you, the person who is accused, have the right to do not say anything, but do not accuse themselves. But they don't have the right to lie. This is a problem that we have in Spain, because at the end, all of the people who are accused lies. Because they do have the right to lie. It's not like in England or the United States. But what's the problem? At the end, the person who lies better, the lawyers who lies better, and who educate their clients to lie, could be have a good result by the court. Because we are humans, and you don't know what's going to be the result of a proceeding, especially when everybody lies in a proceedings. Witnesses lies, accused lies, lawyers lies. So my opinion is that the European Commission should think about this and try to get a law regarding this fundamental right that a person who is accused does not have the right to lie, because it could be a problem for the justice, and it's a lie to the court, lie to the justice, lies to the system, and the person, the victim, can have a bad resolution for their interest if the accused is an expert in lies. So I suggest all the international organizations in human rights to work on that with the European Commission Parliament, and to change this, that they will be helped a lot to especially to the judicial proceedings, because the criminal cases will finish in a very short time, not like what happened in Spain, that you know where you start, but you never know when you will finish. This is what I will explain to. I would like to explain to all of you, and if you have any question and any doubt, please do not hesitate to contact me. And thank you very much.